Thank you, Julian, for doing this. I'd like to welcome everyone to another episode of Health and Aging. Today I am with my good friend, Julian Casal from Casal Moreno. They are South Florida's trust and estate lawyers. Here at Homestead Miami, we're going to try to continue to bring you this important content. We believe that it's necessary in order to age in place, in order to have your financial house in order, and really to expect the unexpected and be able to kind of accept as it comes. So Julian, thank you for taking the time to do this. Where are you guys located, Julian?
Absolutely, Gabe, and no, thank you for having me on. Looking forward to our conversation today. Our offices are located right in the heart of Coral Gables. We're nice and easy to find on the corner of Alhambra and Ponce de Leon.
So let's jump right into it, Julian. What is guardianship?
Is the legal process by which a person, which under Florida statutes can be an adult that's over 18 years of age, takes responsibility for an incapacitated adult. The incapacitated adult is usually, because of some sort of mental illness or physical disability. And it's a process that runs through the court in accordance with the law of the state of Florida. In Florida, we call it guardianship. In other states, it's known as conservatorship, but they are one and the same.
I'm glad you said that because I wasn't sure if conservatorship was the same thing as guardianship. So how does that process work?
You start the process by having a petitioner. Usually that's a family member, a spouse, a child, a cousin, a brother, a sister. And that person will file a petition with the court to determine the alleged incapacitated person's capacity. The court then goes through its due process procedures. They'll appoint an attorney to defend the alleged incapacitated person because we are trying to take away their rights under this proceeding. And they will also appoint a committee of 3 doctors who will perform a medical and mental health evaluation on the alleged incapacitated person. And what those 3 doctors report to the court by majority is the consensus of what the court implements once the hearing is held on the person's capacity. So once this family member becomes the guardian, they are then responsible for making all of the decisions for this person. That can be financial decisions, that can be medical decisions, lawsuits, anything that person may need to deal with. The guardian will now have that responsibility through court orders that are issued in their name and they provide to the providers they're dealing with.
What deems you incapacitated? But what else? Because I know there has to be some fight. Somebody may not want to give up their rights.
It really depends on the medical evaluations, and those are key, right? If we get reports back from the examining committee that are in consensus that this person has dementia or Alzheimer's and really can't be making decisions for themselves, there's not much of a fight, right? Having a guardian will probably be in that person's best interest at that point in time, right? When the committee comes back with conflicting reports, right? Maybe you have 1 out of the 3 doctors that says, well, wait, this person doesn't need a guardianship at all. You'll have situations where you get what's called a limited guardianship, in which some of the rights are taken away, but others are kept by the person. A lot of the times clients can keep the right to vote. They can keep the right to determine where they're going to live, their social environment. Most of the time, if we're looking for a protection of financial assets, then the financial powers are kind of taken away, but maybe they keep the powers to still have environmental control of their own life. Something that can be a big consideration in these cases is if the alleged incapacitated person is capable of going to the hearing and explaining to the court who they want to serve as their guardian, the court does have to give some weight to the preference of the alleged incapacitated person. That's something that carries a lot of weight and helps the judge and the court guide their decision in that respect.
That makes a lot of sense. We have a gentleman that we look after, but we're not with him every day. They've gone back and forth with him because they say that he's a liability to himself, but then he gets back on the ball and he will quickly explain himself. But it's been interesting to see the whole back and forth with him because there's times that we're not around and he's just not taking his meds the way he's supposed to, but he's in charge. As of right now, he's still in charge. So that's a good point. So Julian, what is probate?
So probate is another legal process, and that's the process by which once somebody passes away, the inheritance passes to the heirs of that person. And the heirs are determined either by the law of the state of Florida or by a writing, which normally is a last will and testament that the decedent, the person who passed away, left behind.
And that I guess would fall into their heirs, who their heirs are?
Right. So there's kind of a misconception, and we get this a lot from clients that come to do estate planning. They ask, well, if I don't put anything in writing, that means my inheritance goes to the state of Florida, and the answer is no. The state of Florida has statutes that control the terms of an inheritance for somebody that does not prepare a last will and testament, and that normally is what we call next of kin, right? So in most cases, if you're married and you pass away, your spouse is your primary beneficiary. If your spouse is no longer there, then it's your children, and on down the line it goes. If there's no children, it kicks back up to your parents, your siblings, etc., and starts going down those lines. In cases where clients, do not feel comfortable having those specific individuals inherit entirely, then in those cases are when it's absolutely necessary to leave something in writing behind, right? The will, when a client prepares it, will replace the Florida statutes through the probate administration.
And that's called a living will?
A last will and testament.
A last will and testament. And what is a living will?
So a living will is actually one of the 3 advanced directives. Advanced directives consist of a durable power of attorney, a healthcare surrogate designation, and the living will. The living will is the document in which a client makes decisions about end-of-life issues, whether or not they want artificial life-prolonging procedures or not. The purpose of a living will is to essentially remove that tough decision from the family's hands, make it in life, and the medical team will honor that decision if that document exists, depending on what the client wants.
That is so important. We had a conversation a week ago with Lori Morat. I asked her, one of the questions was, Lori, do you see more people preparing for end of life, people that are getting their house in order? And her answer was very straightforward. She says, I wish I could tell you that I see it. I may see it a little more than I did 20 years ago, but I don't see it enough. People are just not taking the time to prepare, and it goes down to who wants to think about death? But yet here you are on the other side, and you have to then try to put the pieces together between family members who may have had a wonderful family, and they're all loving and caring, and they want all the right things to be honored, but then you can have a situation where they're not so. You don't know what the family dynamic was there, and then the person who passed is not there to say what their wishes were.
Yeah, those situations are tough, right? And from a practical perspective, the legal documentation helps out a lot, because you're essentially leaving the instructions. And in most cases, when family members, beneficiaries, whoever it is that's in charge, they see these instructions left behind for them, there's almost like a sense of peace of mind and calm, that they're like, okay, they left us instructions, we have to follow these instructions, that's what has to be done, we're not going to deviate from this. They'll respect the person's wishes a little bit more. Yes, it's tough to have somebody that's incapacitated, tough to lose a loved one, but the documentation helps, allows people to not have additional stress on top of the grief that they're already. If you can't do any other type of legal documentation, but the client has a concern about their final wishes, the living will is probably the most important document. Fortunately, it does not. Florida is a state that doesn't recognize what we call holographic wills and documents that are written out by hand. You got to have the legal document in place.
How long does a probate case take?
So a probate case can take, anywhere between 6 months to a year on average. It could take longer, 1 to 2 years for most cases. There are cases where you have heavy litigation and it takes much longer than that, right? But on average, 6 to 12 months for most. How do I avoid both of these court processes, guardianship and probate, right? So guardianship can be avoided through the use of the advanced directives that I mentioned earlier: durable power of attorney, healthcare surrogate designation, and living will. In those documents, the client is choosing someone and naming someone and potential alternates to make decisions for them in the event of incapacity. The durable power of attorney has to name somebody to deal with financial decisions, and the healthcare surrogate designation, they name somebody to deal with medical decisions. Then on the probate side, it kind of varies on case to case as to how you avoid probate court. The more common instrument that we use for most clients is a trust. Think of a trust, in, let's put it in layman's terms, as a box that you can put assets in, and the box comes with instructions as to who gets what after you pass away. Somebody is empowered after you pass away to distribute the assets outside of the court per those instructions that you left behind. So you don't need the probate court in that scenario. And the other scenario for assets that helps avoid probate court is jointly titled assets, or assets that are titled in the name of a husband and wife, right?
Excellent information, man. So Julian, lastly, a lot of people think that estate planning is just for the wealthy. Can you debunk that for us?
Yeah, absolutely. It's not, right? You want to avoid these court proceedings, no matter what level of assets you have, whether that be just, you know, a single family home and maybe a retirement account, or, you know, a small savings, or whether you're a wealthy individual. When you find yourself in a guardianship case, your guardian has to be represented by an attorney, and the guardianship case runs from the date the person is declared incapacitated until the day the person passes away. Right? Most other cases last until somebody passes away, and every time the person needs something, the attorney has to go to court to ask permission to be able to use their funds for whatever it is that they need, right? So you can have 10, 15, 20 years of legal bills that are diminishing the value of the estate on the back end. And on the probate side, you know, per Florida statutes, there's a sliding scale for fees that attorneys are allowed to charge. On most cases, that comes out to 3% of the estate. So you can look at that as a 3% tax on your inheritance, even if you don't have federal inheritance taxes. And on top of that, you know, the time that it takes family members to get things organized and get things done in court, you know, you're losing time and money, right? So the idea would be to avoid both processes for all types of clients. I'll give you two quick stories, right? One, and going back to the question of, you know, is this just for wealthy people? The first one, you know, a widow, you know, who her and her husband had worked very hard. You know, they came here from Cuba in the late 60s, and were able to save up. They had purchased their own home, and she wanted to leave the home to her two granddaughters, and decided to go the trust, which for her was, you know, probably the more expensive option, but she felt it was the option that was going to protect her best and protect her granddaughters best. And after she passed away, you know, a couple years after we did the documentation, her granddaughters were able to sell that property, and both of them were able to go to college and graduate school and doctorate programs with the money that came out of the sale of that property. So if you protect it correctly, you can leverage it, you know, down the line. And, you know, the two granddaughters now are high-end professionals. They're doing very well. It's kind of a great story here of a small case that turned into something big, right? On the other side of that, we did have one case where very complex estate, multiple beneficiaries, different points of views really from all of the beneficiaries, you know, 3 separate lines of businesses, each of the beneficiaries involved in one of those lines of businesses. So it was a very delicate balancing act to make sure that the client was able to equalize the distributions, right? We were able to do that through the use of a few trusts, and open communication with the family was key. I would tell you that case would not have worked if the 3 children would not have been involved from the get-go, you know, understanding their roles, understanding what their parents' wishes were, which was the most important thing. And the parents were great about communicating openly to their kids, hey, this is what we want to do and this is why we want to do it. And then at the end, you know, the kids stepping up under the documentation, making decisions for the parents when they could no longer do so. Everything there has been kept in the family, not one request to modify anything in court or challenge anything or anything like that. The parents, you know, one of them unfortunately has already passed away, but no guardianship. It's been a very pleasant experience for the family, and they constantly remind us, you know, and are thanking us, hey, you know, thanks for putting this stuff in place, because, you know, we don't know what we would have had to deal with if this wouldn't have been taken care of, right?
Well, you and your team, I think of you guys as just A1 communicators, you know, so when you're able to communicate those things, you know, fluid, you just make it easier, you know, for family members. So that's a testament to you guys and the work that you do here in the community, man. Good stuff. Thank you. Yeah, Julian, thank you for taking the time, you know, to do this. We're super grateful. I think that these videos and this conversation is going to really help a lot of people, lay the groundwork and really, so for folks to see how important it is to get your financial house in order, no matter how big, no matter how small. You want to get it right. So thank you so much.
Thank you, Gabe. Appreciate the time and had a great time talking to you. Looking forward to seeing the video.